Thank you very much for your kind words, and thank you very much for this very nice invitation to speak here this morning. Let me say from the start that I have not hesitated very long in accepting this invitation. One of the reasons for doing so being that I simply find the title of this conference fascinating. Interestingly, fascinatingly interesting, human rights as a basis for re-evaluating and reconstructing the law. And this prompted me to address in my contribution the question of what should make human rights capable of re-evaluating and reconstructing the law. In other words, what tells you that they are capable of doing this? And what are the requirements for human rights to be capable of doing this? In other words, still, what is it which should make fundamental rights or human rights capable of achieving this? And actually, all these questions, it seems to me, boil down to one simple question. What makes fundamental rights fundamental? The reference to fundamental rights being understood here as including human rights, which indeed form a special category of fundamental rights, I would say. And I will come back on this distinction between these two notions in a few moments. There are two main ideas that I would like to share with you in this respect, and you will see that I was rather pleased somehow to hear also the contributions by the two previous speakers, in that I feel very close. I will express maybe some of the same ideas in other words. I feel very close to what has been said by Mr. Martens and by Mrs. Ringelheim. The two main ideas that I would like to share with you in this respect is that, one, the fundamental nature of fundamental rights is made of three different elements, roughly speaking. There is their role, there is their content, and there is their effect. And these three elements will provide the structure for my presentation this morning. And the second idea is that, to me, each of these elements, and in this, as I said, I feel very close to the previous speakers, each of these elements are somehow under threat, especially the two last ones, which calls for an increased vigilance in protecting them. But because of the title of this general conference here, I will start with the role of fundamental rights. When I look at the title of this conference, Human Rights as a Basis for Re-evaluating and Reconstructing the Law, I can only think that this is somehow assigning a very high task to human rights, re-evaluating and reconstructing the law. And indeed, the subject matter of many of your research and PhD projects, which I also had a look at, confirms the high expectations that seem to be placed in human rights in many different legal areas. And what those subject matters have in common, it seems to me, is an idea that, and this was already addressed this morning, is an idea that seems on the rise and ever more accepted in modern legal theory. And that is the idea that fundamental rights are a kind of founding and therefore validating principle. That they are at the very foundation of every or any democratic legal system, and that as a consequence, every part of that legal system has to pass the test of fundamental rights in order to be considered valid, that is, acceptable. In other words, fundamental rights seem to be ever more perceived as the basic benchmark of every democratic legal system. Maybe this idea has been best expressed so far by the Court of Justice of the European Union in a number of its judgments, and paradoxically also in its recent opinion 2/13 on EU accession to the Convention, which has already been mentioned this morning. And I quote the Court of Justice in that opinion, and that is paragraph 169 of that opinion: respect for the fundamental rights enshrined in the EU Charter are a condition of the lawfulness of EU acts. so that measures incompatible with those rights are not acceptable in the EU. But also in national constitutional law, fundamental rights are increasingly seen as a precondition for the validity of any action by public authorities, including the lawmaker. They are the test which any such action has to pass in order for it to be acceptable, for it to be validated and legitimized. And this is indeed a new task, a kind of new task being assigned to fundamental rights in modern legal theory, in addition to the protection of the individuals. They legitimize state action, which is compliant with them, and they correct action which is not. And national constitutions also bear the marks of this development, especially younger constitutions. Probably the strongest acknowledgement of this foundational role of fundamental rights is to be found in the German Basic Law, in which, in a very symbolic way, places fundamental rights on top of all other provisions and refers in its Article 1 to the, and I quote, inviolable and inalienable human rights as the basis of every community of peace and of justice in the world. As the basis of every community of peace and justice in the world. The Constitution of the Netherlands has a similar opening. Its first chapter is about fundamental rights, and its first article is about non-discrimination. And you also find an interesting provision in the Swiss Constitution, that is Article 35, and I quote, fundamental rights must be upheld throughout the legal system. Whoever acts on behalf of the state is bound by fundamental rights and is under a duty to contribute to their implementation, end of quote. Now, what could be the explanation for this trend? I think quite simply, it very much looks like fundamental rights today are increasingly expected in modern democracies to help ensure that the human person indeed remains at the heart of every legal system and of every single state action. Fundamental rights are no longer about occasionally protecting individuals against state action. It is now also about screening the law in order to ensure its compatibility with fundamental rights in general, by ensuring that their requirements are met. And the reasons for this could well be a kind of perception that without such a requirement of compliance with fundamental rights, modern law risks losing part of its humanity somehow, because it would be either too technocratic, too technical, or too complex, or too efficiency or system-oriented, or indeed too much the work of powerful lobbies. However, if this is the role assigned to fundamental rights, they should also be given the means to fulfill that role. And this brings me to the question of the content and of the effects of fundamental rights, the two other criteria defining fundamental rights. How about the content of fundamental rights? Well, the trouble about the content of fundamental rights is that there is a great variety of such rights, and that their contents are not always very harmonized. This is the result of a certain inflation of legal instruments protecting fundamental rights, especially at European and international level. One of the worst examples, just to give you an example, one of the worst examples of that kind is the ne bis in idem principle. There is a whole bunch of different formulations of this right in a long series of different legal instruments. Only in European Union law, there are not less than 3 different versions of that right. So the question arising in respect of all these texts and instruments and versions of partly the same rights, the question arising here is, are all these rights really fundamental? Are they all equally fundamental? And if so, why? what is it which makes them fundamental? What exactly are we talking about when we refer to fundamental rights and human rights? Actually, and surprisingly, in legal literature, you don't find much on the question why a right is to be considered fundamental, or on the difference between an ordinary right and a fundamental right. And when it is addressed, most often the answer you get is that fundamental rights are those rights which are conferred the status by law or by the Constitution. A very positivistic answer. But you rarely get an answer on why this status has been or ought to be conferred in this way. And I think this is not satisfactory. For if the answer is fundamental rights are those rights which are declared such by the law or by the Constitution of a given country, that would mean a number of consequences. First, that would mean that the fundamental status of those rights is somehow limited to the country concerned. B, that this status is entirely in the hands of the national lawmakers. C, that those lawmakers can confer the status on any kind of right, including rights which may have a very, let's say, local significance or local importance. I refer in this context to, for instance, the right to address petitions, which is a right that you have in the Belgian constitution, that you have in the Swiss constitution, but you can't possibly claim, I think, that this right has a kind of universal dimension. Or the right or the freedom to use any language that you also find in the Swiss constitution. And on the other hand, the other branch of that third consequence is that those national lawmakers could just as well ignore in their constitution more basic fundamental rights, such as, for instance, the freedom of expression. So you see immediately here that there is a kind of tension between the fundamental nature and the status as fundamental right. And last consequence, well, if everything is put in the hands of national lawmakers, the consequence is that those rights can indeed vary from country to country, which is not particularly conducive to legal certainty. So I think you immediately feel that this cannot be the whole truth. That beyond those kind of national rights, fundamental rights, there are also rights which somehow impose themselves as fundamental, because they correspond to essential and more or less universal needs or aspirations of every human being. The right to life, the right to dignity, to respect for private and family life, to freedom of thought, of religion, of expression, to mention but a few. And those rights, given their universal dimension, you can rightly call, I think, human rights, because they correspond to something which is common to all human beings. And as a consequence, they should not be left entirely in the hands of national lawmakers. And thus, by their very nature, those fundamental rights with a kind of universal dimension, a dimension which transcends national categories, call for an international protection as a complement to their protection at national level. For a double reason: in order for their universal dimension to be acknowledged, and also for them to be better protected by preventing that they could find themselves entirely left in the hands of national authorities, with the consequence that they could be given all sorts of different contents, thereby ignoring their universal dimension and weakening them. A good but sad example of what national lawmakers can do with such universal rights are, for instance, the current attempts in Hungary to reintroduce the death penalty. But at the international level too, we have to be careful because of the inflation of legal instruments containing different versions of the same rights. If at least some sort of harmony is maintained between those instruments so as to preserve legal certainty, then international protection of fundamental rights enhances their impact. If, however, this is not the case, international protection only creates more confusion and ultimately weakens fundamental rights. And if you're interested, we can have a word afterwards in the discussion on some examples of confusion coming up in important areas protected by fundamental rights in the relationship between the European Convention on Human Rights and union law. I'm thinking here especially on about the directives concerning fundamental rights and procedural rights in criminal procedures. This is certainly a particular challenge. Now I come to the third element that I wanted to address this morning, and these are the effects of fundamental rights. For indeed, compliance with fundamental rights does not end with giving them a proper content. It also requires giving them the effects which are inherent in their specific nature. And this comes down to regulating their relationship to other non-fundamental rights. Remember what I said earlier on. Fundamental rights have a foundational role. The purpose is to allow them to validate and legitimize the functioning of the legal systems concerned. They correct state action which is not compliant with them and validate state action which is. All of this can only work if you make fundamental rights the higher norm, against which the others are to be tested. You can only legitimize by reference to a higher norm or value. And indeed, fundamental rights, fortunately, are in practice very often considered the higher norm by the courts applying them. For if it is not higher, it cannot prevail and therefore not set aside any other norm or action not compliant with fundamental rights. By saying this, I'm not rendering all fundamental rights absolute or not susceptible of limitations. I'm not addressing the question of the limitations to fundamental rights, but rather their place in the hierarchy of norms. And interestingly, I draw your attention to the fact that we seem to have a new kind of problem in this respect with the European Union. And we have to be careful about its impact on other legal systems, knowing that union law, of course, is integrated in the national legal systems of the member states. It was already emerging from some parts of the case law of the Court of Justice, but it now got some sort of formal confirmation in Opinion 2/13 on EU accession. You remember the quote about fundamental rights that I referred to at the beginning of my presentation about the condition of the lawfulness. I quoted, "Respect for the fundamental rights enshrined in the EU Charter are a condition of the lawfulness of EU acts, so that measures incompatible with those rights are not acceptable in the EU." Fine. But just after, in the next paragraph, this statement is qualified by the Court of Justice in the following way, and I summarize the 3 following paragraphs. The Court of Justice basically says, fundamental rights must be interpreted and applied in accordance with the EU constitutional framework, and notably, the objectives being pursued by the EU, which include, for instance, the free movement of goods, services, capital, and persons, citizenship of the Union, the area of freedom, security, and justice, and competition policy. The question arising here is whether this is compatible with the foundational role of fundamental rights. With this foundational role, that they should be, whether that is compatible, that they should be interpreted in the light of the objectives pursued by the EU and of what it takes to achieve them. Could we, for instance, imagine a state arguing in Strasbourg that fundamental rights apply to it only to the extent that they permit certain objectives to be achieved. And reality indeed seems to confirm this approach in EU law. For what we see is a kind of increasing number of areas where the impact of fundamental rights is being somehow limited through interpretation for the sake of preserving the efficiency. And here I come close to the considerations by Professor Martens on the budgetary considerations. We are not far away from that, but here it is more about efficiency, the efficiency of some mechanisms, either mechanisms relating to mutual recognition in the European arrest warrant, in the application of the Dublin regulation, etc., or mechanisms like the one that you find in the return directive. In the area of mutual recognition, for instance, I don't want to go into any details, but roughly speaking, the problem arises in the fact that the Court of Justice goes so far as to deny judges in an executing member state, a state which has to execute a judicial decision from another EU member state, that the Court of Justice denies in some situations judges in an executing member state and denies that right, including under the Convention on Human Rights. It is stated with so many words in Opinion 213, including under the Convention any competence to assess respect for fundamental rights of the person concerned in the requesting state, regardless of the circumstances. So this is a massive limitation of the effects of fundamental rights in the executing state, including, in the opinion of the Court of Justice, under the European Convention on Human Rights. And the reason for this is the preservation of the efficiency of the mutual recognition mechanisms, as the Court of Justice stated, for instance, in the Radu case, which concerned the right to be heard of a suspect who was the subject of a European arrest warrant. And the Court of Justice said, I quote, "The European legislature has ensured that the right to be heard will be observed in the executing member state in such a way as not to compromise the effectiveness of the European arrest warrant system. In such a way as to not compromise the effectiveness." And considerations of this kind can be found in several judgments of the Court of Justice and therefore seem to be rather typical for this court's thinking in this area. You find similar quotations in NS, for instance, concerning the Dublin II regulation, and in other judgments concerning child abduction, for instance. Now, what I would like to say, and don't misunderstand me, efficiency is certainly a very legitimate concern. And there is no question of challenging the wisdom and the need of those mechanisms which are addressed here in this case law. But the question is, how far? How far can such considerations go in limiting the effects of fundamental rights? It is certainly true, and I think this is important, it is certainly true that under the Convention 2, under the Convention, fundamental rights are not absolute either. They can be restricted for a limited number of legitimate aims if those restrictions are proportionate. And the evaluation is made on a case-by-case basis. On a case-by-case basis, according to the methodology elaborated in the provisions of the Convention. But I see another methodology being applied here by the EU. It's balancing fundamental rights taken globally with the efficiency of a number of mechanisms considered to be of the same importance as a respect for fundamental rights. It is asking how to preserve, if I may put it in very simple terms and simplifying terms, sorry for that, it is asking how to preserve the system from the effects of fundamental rights rather than asking how to preserve fundamental rights from the effects of the system. Now, what is the risk? Well, there is a clear risk of fundamental rights being instrumentalized. Why? Well, as we noted already, fundamental rights are considered to fulfill a double function, a legitimizing and a correcting function. And these two functions are closely linked. It is because of their correcting effect that fundamental rights also have a legitimizing effect. Only what could have been corrected and was not ends up being legitimized. It is like praise. It is only if I have the right to blame you that my praise will be genuine and worth something. Yet what we see in those judgments that I mentioned in the field of mutual recognition is the fact that the Court of Justice makes use of the legitimizing effect of fundamental rights to the full, while at the same time restricting its correcting effects by allowing those only to the extent that they do not disturb the efficiency of the mutual recognition mechanisms. And this is a kind of cherry picking. This is a kind of cherry picking which massively weakens fundamental rights. For the more fundamental rights are relied on for their legitimizing effect, but at the same time deprived of their correcting effect, the more they find themselves reduced to, if you allow me the expression, to mere propaganda. This is somehow changing the nature of fundamental rights as we have known it so far. The problem with this trend is that it might very well spread further across EU law and indeed also in national constitutional law, given the level of integration of union law in the national legal systems. It can spread, it could well spread as a kind of tempting and convenient way to deal with fundamental rights when they appear to stand in the way of any other objective considered worthwhile to be achieved. But the question is, where will that stop? Today it is mutual recognition and the return directive, and what will be next? Sorry for Mr. Martens, but I see here too a kind of a Pandora's box possibly being opened. And the question is also whether that kind of case law will not in the near future be relied on by states before the Strasbourg court. So in conclusion, a very quick conclusion. I referred at the beginning of my presentation to two main ideas. One relating to these three composing elements of fundamental rights, and the fact that certainly the content of fundamental rights and the effects of fundamental rights are a bit under threat for different reasons that I mentioned. I would like just to add a third and final idea to these two ideas that I presented at the beginning of my exposé, and that is the following, that I think if fundamental rights should continue to be able to re-evaluate and reconstruct the law as rightly suggested by the title of this conference, one should be well aware of what makes them fundamental and protect that. In other words, in order to be able to protect, fundamental rights themselves need protection. Protection of their fundamental nature. Thank you very much.